webinar is for parents of older adolescents. So we're looking at ages 16 to 18, and adult children with special needs. It would also apply to students in school who are aging out into adulthood. So you're looking at ages 18, maybe to 22. So tonight's presentation is on guardianship and alternatives to guardianship. It will cover powers of attorney, supportive decision-making, healthcare proxies, living wills, and special needs trusts. Our presenter tonight is attorney Regina Brandow. Regina has been practicing for more than 25 years. She specializes in transition planning, special needs planning and trusts, and estate planning. William Floyd School District has hosted Regina's workshops and presentations for almost 20 years now. So we're always very fortunate to have Regina share her expertise. If you go to Regina's webpage, which is brandowlaw.com, it's also on the flyer right underneath her name. You'll see a variety of recorded videos, many on the topics that I just mentioned. So before we begin, I do want to say that it's a good idea to apply for OPWDD services prior to your child exiting school. You can do this whenever your child, well, when your child is at any age. Ideally, it's good to start transition planning when your child is in middle school. OPWDD asks for many documents that that are on file with the school. So those of you who are not familiar with OPWDD, it stands for Office for People with Developmental Disabilities. Your school transition coordinator can help you start the process. And we're going, like we said at the beginning, if you have questions, please put them in the chat and we'll answer them. Regina will answer them, as we go along. So now I'm going to hand it over to Regina Brandow.
We already have questions, Regina. Do you want me to give them to you and then you can start? Because otherwise they're going to be taken away as the list grows. The first one was, I was told that my care manager can help with getting either a temporary guardianship or a guardianship in this. Is this true? And the other question was, is there a PowerPoint presentation transcript? And my 17-year-old was recently diagnosed. Do I have to wait for the full report from her? Hold on. Only getting half of this message for some reason. Wait for the doctors to start the application process for OPWDD. That's it.
Okay, so let me answer about, let me piggyback on what Wendy was saying. OPWDD, I would, when a client comes into me and they say that they have not started the process, I will tell them to turn around. I'll be here, but definitely start the process with OPWDD now. You are a limited resource and you need to make sure all the testing and so on is submitted. In regard to care coordinators and other individuals that can assist with guardianships, there are, I know of a few people that do it. They're not attorneys. And it all depends. And I don't know, your care coordinating person, and I'm going to make a statement, and I know this is being recorded. Sometimes your care coordinator this week is Wendy. Next week, it will be Nancy. And then the week after that, you're going to be talking to a supervisor because it's just a very frustrating process. So the more that you can be self-reliant and not reliant on the care coordinating agency, because it's just a lot of turmoil that they're going through. And the really good ones get promoted up and then, or they look for other positions. So that's all I'm going to say. I've had a couple of good care coordinating contacts, but now when I call, it's I get crickets back. Even me, like I know this person I co-presented with, so it's a frustrating process. In regard to the doctors, um, I, I would, the question I think was relating to OPWDD, right? To continue with the process with the doctors, right?
Yeah, she wants to know if she has to wait for the full report from her doctor to start the application process.
For OPWDD or guardianship?
OPWDD.
Yeah, I mean, it's all about the evaluations and the testing that you're doing. So I am not an OPWDD expert. And I will just say this, when somebody calls me and they want to do an appeal for OPWDD, I do not do appeals for OPWDD. That seems incredible, that attorneys should be doing OPWDDs appeals. In my opinion, I think psychologists should be doing OPWDD appeals because they're talking to other psychologists. And I've recommended some really good psychologists that do help in that process. They're great advocates for your children. That's just generally what I'm going to say about OPWDD. Tonight, we're talking about the whole idea of now that I'm 18, what is expected of me, and what type of documents do you think, or that person should have when they're 18 years of age or older. So before 18, you are considered a guardian, right? The parent is a guardian of that individual. And you can make medical decisions and or dental decisions on behalf of your child. Come 18, New York assumes that everyone can make their own medical and dental decisions for themselves. Now, it's a really tough concept to figure out, but just because I'm 18 doesn't mean I need to understand a medical decision. It's the ability to understand that there's a risk. You can reach out to other individuals about whatever the procedure is, what medication that you need to take. If that person has that ability to process that information, that's what's really critical about post 18. I have a healthcare proxy for myself. I have a power of attorney. Every loved one that I know who's over 18 that is able to sign, I prepare those documents for them because they are so important. Tonight, if I leave here tonight and I get in the car and I suffer a traumatic brain injury in a car accident, I want my loved ones to be able to care for me, pay my bills, talk to my doctors, do whatever, even transfer assets out of my name in order to qualify for benefits, because I don't want them to go to court. A lot of parents, I will just say at the get-go, at age 18, will say, my child can't make decisions for themselves, or they would make the wrong decision. They lack judgment. Guess what? At age 18, I lack judgment. We all do. So that's a little bit different. So I want you to, take a step back and really look at your son or daughter's evaluations to see if they have the ability to make those medical or dental decisions for themselves. Financial, that's definitely a tough situation because kids, and at age 18, they're a kid. At 22, they're still a kid. they haven't been exposed to the whole issue of cash. It's really hard. It's like, here's a debit card, go shopping. And they don't have that understanding of here's a $20 and, and the toothpaste cost, $7. I should be getting $13 back. So, to be an advocate for your child, I would definitely start exposing them to those opportunities, if you can, about exchange of money and understanding money is a limited resource. So when a person is thinking about guardianship, when they contact our office, part of our process is to always look at the documentation from the school district. And I always look at the psychoeducational evaluation. I also look at the IEP. And I also want to meet the individual. Guardianships is a very tough process, and it's definitely more scrutinized now than before, because you're saying that this person is unable to make decisions for themselves. It's blanketed. So it's almost like, you're taking their rights for self-determination away. So that's why the courts are taking it very seriously, and they should. And it's funny, sometimes I have parents that, they want to do a guardianship, but like, I don't understand. I'd rather do a healthcare proxy and a power of attorney any day. It's easier, it's less expensive. Obviously, there's no court involvement, obviously, if the person is able to sign. And parents do get concerned about that because the one thing that they're uncertain about is that my child can be manipulated. So all of us can be manipulated. I could be manipulated. I could be scammed every day of the week. But so it's not a bright line test about your child. But with the power of attorney and the healthcare proxy, I think parents' concerns are that that person could change their mind. In 5 years, they don't necessarily name their parents, they name someone else. And that could be, unsettling for parents. So guardianship involves a aspect of how your child is functioning day to day. So yes, there is that cognitive component to it, which is the IQ. And then there is the activities of daily living. How much can your child do day to day? What you need to do for your child day to day. So and the cases are, it differs. And I've seen some cases where guardianship was denied for it. The child had a license. The child was able to navigate the subway system by themselves, was alone in their home, for a certain period of time, able to take their own vitamins and medication. So it's not necessarily one key factor, it's a mixture. And when I meet with the child that you're thinking of a guardianship, we ask a lot of questions. And we also ask if the child would consent to your mother and or father making all decisions for you, because that's what a 17A guardianship is like. Now, there are other types of guardianship. It's a Article 81 proceeding in Supreme Court. And that could be tailored to the person's needs. So I just want you to know that 17A guardianship was designed for people with intellectual disabilities and developmental disabilities. And Article 81 guardianship, that was more tailored for people who were diagnosed with dementia, but with the onset of autism and how there's that high functioning autism where it may not be a 17A guardianship, but it may be an Article 81 guardianship because this person needs assistance with certain aspects of their life, but they're able to understand and appreciate risks and benefits.
Regina, we have a question.
Sure.
We have a couple of questions, actually.
Yeah.
Hi, my son is 17 years, 3 months, autism. When should I start to apply for the partial guardianship? We live in Queens. He has psychological since 2023. Do I need to obtain an updated one? Will a checklist of required docs be guided today?
I think she meant given.
So I think on the for guardianship, you could go on the Queen's Surrogate Court and you could see the list of documents that you need and the forms, the petition and the doctor's affirmations. I will tell you, Queen's does require doctor's affirmations. All of them require doctor's affirmations within 1 year, but they're also requiring that the testing be done within 1 year. So 17 and 3 months. Now, usually people wait until their 18th birthday to file for guardianship. So it's a timing issue on that in regard to the testing that you're going to use. And Queens has a new surrogate. The previous surrogate did hearings where it was via Teams, remote. I don't know if this is going to change in Queens, but you could go to the Office of Court Administration and you can drill down to Queen's Surrogate or go to their website directly. There's also on a workshop that I did for William Floyd a number of years ago, and the forms are still appropriate. You can download the forms and you can see it for yourself. What you do need is a certified copy of a birth certificate. And I will be getting into, the details of what is needed for a guardianship. The 2 doctors or 1 doctor and 1 psychologist, but I just want you also to know that everybody is fingerprinted, every adult that lives in the house with the soon-to-be adult child, and they do a background check and they do a CPS check. And I'm finding that the court may be ready and we have a hearing, but it's subject to those reviews from CPS and criminal background. And I just want to say this, that doesn't bar you from being a wonderful parent and a wonderful guardian. It's just that you have to provide some explanations if there is, something in your background. And I suggest if you do proceed and you have something in your background, to submit something of an explanation first. Don't think they're not going to find it, because they do. They always do. So the advanced directives that I usually prepare for someone that's over 18 includes a healthcare proxy, a HIPAA. And now the healthcare proxy, I want to explain, is that I'm just naming a person. So, and you can download it from the Department of Health, New York State Department of Health, yourself, and there's frequently asked questions. And I may be able to make medical decisions today, but if at some time in my life or period I can't make medical decisions, on my healthcare proxy, I'm naming individuals. and it would be in succession order, meaning, you know, one, my first person, my second, my third, and they would go reach out to my first person. If they're not there, go to the second and then the third and so on. Healthcare proxy, so again, to fill out a healthcare proxy, I don't need to have or understand the underlying medical decision. You know, quite honestly, I didn't go to medical school. And a lot of times when a doctor is speaking to me, I don't understand a concept. And I do reach out to individuals for assistance. So I know on my healthcare proxy, naming someone, I know who would be able and be willing to make a good decision for myself if I could not. And that, if I could not, it could be situational. It could be, I could be stressed out. I could, unconscious. There's a lot of different situations that where I might not be able to make a medical decision. The HIPAA is a release of medical information, and I always name those agents so they can access hospital records, talk to your insurance company. The FERPA, that is the educational records. And if your child is going on after school to another post-secondary school, vocational or college, Suffolk, Nassau County, and so on, the FERPA is a release of educational records. Some parents have a very frustrating time where they may be paying for the program, but the program isn't going to speak to you about your child's records. And it's very concerning because sometimes, you know, you may have you know, related to, you know, a mental health crisis, you know, and the child has in, you know, in the program. So you can see you just don't need a educational record. You also need a healthcare proxy and a HIPAA. And I will just mention for mental health crisis, a social worker, any good social worker, even though the healthcare proxy will say, or even like a guardianship, will say that I'm the person that should be speaking for my son or daughter. A social worker in a crisis will always ask that child, do you want me to speak to your parent? And that child has every right to say, no, not right now. So, because they're in crisis. So guardianships are, you know, it's very, you know, parents want it, you know, as a blanket, but it may not necessarily be that wonderful, you know, poison, wonderful pill that you take, that will gain you access to everything, you know, that your child is doing. And I will mention that medication, a guardianship, even if I had a guardianship of my child and my child is refusing to take medication, that would be a separate proceeding. So I just want parents to understand that. The other document that I do is also the Social Security consent form. But if you are your child's payee rep, then, you know, you have access to your child's records through Social Security. And Social Security, you should be applying for your child if you think that they won't be able to be gainfully employed after school, you know, post 18 years of age. And we do have on the website a number of transition webinars that we've done in the past. I have one coming up March 20th to talk about that. That's not my presentation. That's Brian McIlvain from Silo. He assists families with Social Security and OPWDD. Now, the power of attorney I talked to you about, but that's another useful tool for, you know, someone that I don't need to be incapacitated. I could be in Tahiti for 6 months and my named person could be paying the bills, taking care of things. I do prepare a very robust power of attorney so that named agent, it's kind of scary when you read it, can really step in your shoes and take over your life. And then there's trust. So, sometimes I'm bringing this up, and the reason being is, regardless if your child is capable of signing these documents, they may be on benefits, and the trust is a good way to protect that money that you're going to leave behind, so your child remains on benefits, and someone else is managing your money if something happens to you to benefit your child. So you're not leaving your child with, 300,000 in his or her lap. So which is good. Now, Article 82 is supported decision-making. That is a process where, and I think that process, anyone under a guardianship or under advanced directives should always consider this and maybe go through the process. So I've seen individuals under a power of attorney be almost like a bully, if I could say it that way, like, Mom, I'm your power of attorney, we're going to do it this way. So supported decision-making shouldn't only be for people with developmental disabilities. I think it should open up to anyone and everyone, mental health, people who are diagnosed with dementia and so on. It's the ability to carve out that person, the individual with dementia, what decisions can be made, what concerns that they have. They may have some concerns that are outrageous, but it should still be heard, and then in some aspects still address it. Now, supported decision-making, I have not seen any document that a hospital or a bank would approve. So again, even with supported decision-making, you would still need a healthcare proxy and a power of attorney.
We have a few more questions. I'm going to jump in there before you start the next page. From Jamie, I started the process as soon as we got a care manager. We lost our Medicaid insurance. So now I don't know what to do. The OPDD process is what I'm talking about. That's one. And then we have, do you need a lawyer to get this document? Do I go to family court in Nassau and ask about guardianship? There's a few more, but I'll just give you those two and then we'll go from there.
Okay, so OPWDD, Wendy, you're going to answer?
I was just gonna say the question about family court in Nassau. Do I go to family court in Nassau? You don't need a lawyer. You can do it yourself. It's very difficult. I've had parents do it, and it's taken probably about a year for them to get all of the documents typed up or written up, to get the doctor's forms filled out, the psychologist forms. Things have to be notarized. So it's a very, tedious task. And then once you get it into the court, you might get it back a dozen times. If you don't, cross your T, if you don't dot your I, they're very, very particular with that. So I did put down, it's not the family court, it's the surrogates court. So I did list in there, you'll see the address and the phone number. So I would call them because their forms are very different than Suffolk County's forms. What am I?
There's one more that is important too. Can you have money in a trust for a child that is living in a group home?
Of course, if it's in the right kind of trust. So I think there was a previous question, Nancy, that you were talking about OPWDD.
Yes.
What was that again?
Okay, the woman wrote, I started the process, and as soon as we got a care manager, we lost our Medicaid insurance. So now I don't know what to do. The OPWDD process is what I'm talking about.
So again, I apologize. Tonight's presentation isn't about OPWDD. I don't work in that area. I know Wendy facilitates as a transition coordinator. And I don't know why you lost Medicaid because of, applying to OPWDD. Doesn't make sense to me. But there are, or I would go back to your care coordinator and find an explanation if you can get one. Ask to speak to a supervisor. If you don't, you could also reach out to Silo. It's an agency that you could get some answers for. You could, but OPWDD is eligibility. It's just talking about if I have a developmental or intellectual disability that qualifies me for eligibility for OPWDD related services. Medicaid is separate. Medicaid is a means test. It pays for those services under the OPWDD umbrella. So that portion of Medicaid, I don't know if your child has any assets or income, things like that. So you should look into that, and or call your care coordinating agency. And if you're not getting answers, speak to Suffolk Independent Living Organization, SILO. Their telephone number is 631-880-7929.
I think they just changed it to self-initiated living option.
Oh, thank you. Thank you. You're
Yeah.
right. Thank
Yeah.
you. You're so good. Thank you. So,
I'll put the contact information in.
thank you. So the Article 17A, which is what we're talking about for guardianship, if you proceeded for guardianship, I put this slide together, and I want you to think about, so this is what the court is looking at. So the surrogate, there's the surrogate court, and the surrogate is actually the judge of the surrogate court, and he or she is acting as a gatekeeper. They want to make sure that that person needs a guardianship. And you have to consider the best interests of the person with the disability. Not the, and there are, and the statute is a blanketed statute. If I'm saying I need a 17A guardianship, it is indefinitely for life. It is not for the next 5 to 10 years. So that's the 17A is essentially, I can't understand risks and benefits and the consequences. So, and this is, oops, sorry, I hit that by mistake. So one who is incapable of, and this is permanently, incapable of managing oneself or their own affairs because of intellectual disability. And then the other one is that it's permanent in nature and understand and appreciate the consequences of their decisions, and it's attributable to their developmental disability. So I will just share with you, people diagnosed with autism. I met a young man, his mother did the guardianship herself, and she came to me and she wanted to undo the guardianship. She was very supportive of it. And the young man is capable. He's capable. He goes to the doctor himself now. And he is now in his 30s, probably mid-30s. He's a musician. He's able to go to work. He keeps his own calendar. And I would say he would qualify for a termination of that guardianship. At the time, it was, when the mother filed for a guardianship, it was a number of years ago. And the young man maybe didn't have that capability. But now, he has matured and or gained those skills that are necessary to navigate life, right? Our experiences help us in navigating life. So somebody's drawing on this, is that?
Yeah.
I did, I'm sorry. I
That's
did the
okay,
funny
that's
thing.
okay, I wasn't
Sorry.
sure, so that's fine.
I'm very sorry.
That's all right.
While somebody else earlier asked if you have a transcript of your PowerPoint.
If you go on our website, we do have in Spanish and English a audio recording. I don't believe we ever transcribed it. I think Zoom automatically transcribes. So I don't know if this one is going to be transcribed or not. And it's not perfect. It's not like a court reporter. So. All right. Now the difference of Article 81 and versus the 17A, the 17A I mentioned was intellectual disability and developmental disability. It's a totally different flavor, the Article 81, and it does look at functionality, and they don't want you to submit medical documentation. They're very HIPAA sensitive, if I could say it that way. And it's all based upon the hearing where can the person manage their own affairs? Can they prepare their own meals? Can they go to the doctor? They don't necessarily have to drive to the doctor, but do they know how to schedule an appointment for the doctor and so on? I was participating in a case a number of years back, and the children wanted to do a Article 81 guardianship on mom. And, it was very funny. They were saying mom needed a guardian, and just the last Christmas, mom made, ziti, she made lasagna, she was making everything. She hires landscapers for her house, to manage her house and, attend to the lawn and the snow shoveling. And I just saw the expression of the judge. And, obviously they lost that case, and fees can be pretty high in those cases. And because of that, I think those petitioners had to pay the other attorneys, the attorney for mom, the children had to pay for mom's attorney that she had to hire. So if you're moving forward on a guardianship for under Article 81, obviously you want to be certain. Now 17A is more of a diagnostic driven type of proceeding. You submit the doctor's affirmations or the psychologist's affidavit, and it's based upon that. And I will mention that the court is really relying in Suffolk on guardian ad litem's, and that is an attorney in the community that is appointed that looks at the petition, the underlying doctor's affirmations and affidavits, also requests all the testing on the child and the current testing, and will meet with the child and meet with the parents, also reach out to third parties and in order to write a report to the court. Why a guardian ad litem is appointed? It's because the court doesn't have the staffing to do that and to go out to a home visit. I've been appointed by the court to be a guardian ad litem, and I do schedule a home visit. I'm very intrusive. I actually, when I meet with the family, I meet with the child. I try to meet with the child alone. I ask to see the child's room. I look at the refrigerator. I don't want an adult child to be living like Harry Potter under the stairs. I'm also looking at the refrigerator to make sure it's not just a bottle of vodka in there. So it is intrusive, and the reason being is because you're saying that you're taking away, someone's civil liberties for self-determination. And there are cases where the child does need a guardianship. Based upon your questions you ask, and you are supportive of the parents, and you write a report saying that, the child does need one, and the parents would consider the best interest of the child based upon, the history, what they've done for the child. They've applied for OPWDD, they've applied for SSI. The school district is not saying that they're not coming in unfed, dirty, and so on. So even with the report that's submitted to the guardian, to the court, the surrogate will still want a hearing. And those hearings are on the record, and it's very intimidating for the family. And when I represent the family, we prepare them, and we don't tell them what to say, but we do explain what type of questions that they'll be asking. And usually there's always a reporter, a primary reporter. So let's just say it's mom. Mom will explain that my child can't take a shower, without daily hygiene, without being prompted, a cue each and every day. Yeah, they can dress, but they would dress inappropriately. They would wear summer clothes on a freezing cold day or something else with no concept of, the outside world. And at the hearing, the parent or the loved one would be talking about to the judge, answering those questions, showing that this person really cannot, day to day, make any decisions without the support or the decision making on behalf of the parent. They can't take medication. They can't schedule an appointment. If the fire alarm goes off, they won't do anything. So those are the type of things that are shown in the hearing. And if it's shown, then the judge will sign off on a guardianship. So it's not, it is a daunting process. So that's after the paperwork is done. And I will just mention, in Hofstra Law School does have a clinic. It is a free clinic, and where the law students will do the petition and will appear in court. And I've seen them, and they're good. So you might want to reach out to them. I don't know the number offhand, but I will try to look at my phone to see if I can find it, in case anyone is interested. So are there any questions?
There's quite a few. I'll give you started, and then maybe Wendy can pick up the bottom part. Oops, somebody just moved on me. Here we go. Okay, the first one we have here is, she did the guardianship for my son, but I'm unsure if I have guardianship of guardian of his property based on the certificate and decree I received from the court. How do I know how do I know and find out? The attorney who did this pro bono no longer works for the firm she was employed with. I reached out and was told she no longer works there.
So if you could look at the decree, and if it's a 17A guardianship, believe me, it's probably just going to be person only. You don't want to have, well, so in Nassau County, it's a little bit different, but what you have to do for guardianship of the property, the person has to have property. So what property does the person have? Let's just say I have $10,000 in my name and I need my mother to be appointed not only of the person making medical and dental decisions, but of the property. And I will tell you, a guardianship of the property, you need court order to make a withdrawal. So please, and that's a very good question because I didn't mention this in the beginning, do not have property in your child's name. You as a payee representative, you don't need to file a guardianship on property if you're the payee representative because you have control over it and the relief sought from the court you already have. So I would suggest strongly look at your child's resources, make sure that they don't have any property, look at any savings bonds, look at any 529 accounts. If you can, get rid of them now before you apply for guardianship. I will tell you the guardianship of the property, again, if $10,000 goes in and you wanted to pay for a camp, you actually have to submit a withdrawal proceeding. And it is not fun. And the judge usually is very conservative. Why can't you pay for it? What other resources do you have? Can Medicaid pay for it? Because OPWDD through self-direction partially pays for these things. And the judges are aware of that now, and they will ask these questions. Hopefully that person doesn't have property in their child's name. And I would, if it's in Suffolk County, most likely it's just person only. I wouldn't wish a guardianship of the property on anyone.
Another question is, my son is 20, considered high functioning, but has proven he does not take the important medications and leading him into being a crisis. Is that enough for getting guardianship? And then she does add to it, I'm sorry, I meant taking his medications on his own. He takes it when he has support.
That in itself on its own, no. I mean, it's like that puzzle. And there's all different kinds of factors regarding, a guardianship. And when you say high functioning, the court is going to scrutinize that and really consider maybe the individual would be best suited in an Article 81, the other guardianship, where it could be tailored to your son's disability or his needs relating to medication. I don't know how he is with finances, things like that. So it can be tailored. So this is a little bit more information about guardian ad litems. So guardian ad litems used to historically be not appointed unless the court just saw something that raised a flag, like if there was a criminal background or a CPS charge. I will tell you guardian ad litems are being appointed more readily by the courts. And they will do a investigation and write a report and appear at hearings, and a lot of times the judge will award a fee. So and that would have to be paid by the parent. And I can't even, where finding fees could be more than $3,000 from that guardian ad litem. So just as something as an aside to prepare you, for this process. And then the hearing, again, this is the hearing process. And believe it or not, a hearing could last maybe 20 to 30 minutes. The guardian ad litem will not review the report. Everybody has seen the report, but that is admitted into evidence. And the guardian ad litem sometimes may or may not ask questions of the parent or of the child. The judge will definitely be asking a lot of questions. So, just be prepared for that. Okay, so jury trial. I've never seen a jury trial for a 17A guardianship. Usually people waive that. And the burden is on the petitioner, meaning you're the person asking for relief. Your burden is to show that why this person needs a guardianship. And then there are a number of case trends. So, I will say that in Kings County, there was a surrogate that right off the bat didn't like 17As because it was just a blanketed guardianship. It wasn't tailored to meet the needs of the individual. And a lot of her decisions were turned on what resources did that individual have? Did they have a supportive family? Why do you need to have a guardianship? Can the person sign a healthcare proxy and so on? So it's something that you should be aware of, because a 17A cannot be tailored to an individual. Where that person was asking about the high functioning autism, a 17A is literally saying he or she cannot understand risks and benefits. And one of the questions I would be asking is, oh, do you know what a risk is? And, if the person understands a risk, and this is the hard concept to take, where sometimes we know what a risk is and we're still taking it, because we want to. And bad judgment doesn't mean I need a guardianship. So these are miscellaneous issues that I thought might be, just because you're divorced doesn't mean that both parents can't be co-guardians. And sometimes we have clients that call up and say, I am the custodial parent, so I should be the guardian, and I want to go for a contested guardianship, and I don't want the other parent to be a guardian. I will tell you, the courts favor access to family. They don't like to see, especially medical decisions for the parent, like to see that the person isn't have that ability to make medical decisions with the other parent. And the cases are very fact specific, and the courts will really try to push both parents to mediate and perhaps be a co-guardian or come to some sort of arrangement. So a standby guardian, what does that mean? That is somebody that's named on the petition, but they have no standing. They don't make any medical decisions or any dental decisions. And if that guardian is no longer, that standby guardian isn't automatically the guardian now. They still have to apply to the court and say, I'm ready to be the guardian. And they would have to go through, they have to submit a petition, they have to go, and asking for relief to be appointed a guardian. And there will be fingerprints, and there are CPS background and criminal background test investigation. And then jurisdiction after the appointment. As I said, you retain general jurisdiction over that person with the disability. and it's for indefinitely for the life. And you don't even, and this is why this statute is coming under fire, is because you're the guardian for life and there's no annual check-in. So in year 2025, you might be a great guardian for your son or child. And then later on, there's no annual check-in, and that guardian, we're human beings, may be subject to, mental health, failings and so on. You're no longer a good guardian. How is that court aware that you're no longer a good guardian? So that's why Disability Rights of New York is really trying to change the there because they think that it takes away the person's, civil liberties, and there are no checks and balances in place. There is a corporate guardian that could be appointed. I've never seen where a corporate guardian is appointed for the person other than a group home. And they are very good. They, want to make sure that that person is cared for and attended to. And then, so we talked about the staleness of doctors must be within 1 year. And then Queens on top of it says the testing has to be within 1 year. Nassau County, somebody asked a question about Nassau County, has to be within 2 years. So each surrogate is a little bit different. And guess what? Fingerprinting, just in Riverhead, it used to be parents didn't have to be fingerprinted. Now everybody is fingerprinted. So, it's just, we have to keep on top of it. It's just, this, and the surrogates change and they meet and they talk, the surrogates talk amongst themselves and about a number of issues. And one of them is the 17A. And a guardian, if I'm appointed a guardian of the person under the 17A, there's nothing in the statute says that I would be compensated, okay? Temporary, if an emergency arises. So somebody asked for a temporary guardianship or limited in the beginning. I will tell you, I've never seen a temporary guardianship with the surrogate courts. They just go for the guardianship. And I will tell you, it is taking more than, I would say, 8 months, just for the process, between submitting it to the court, the clerks reviewing it, a guardian ad litem being appointed. They may ask for an adjournment to write their report. Then there's a hearing, and then there's a decision. And the hearing, the decision might not come for 60 days after the hearing. Oy vey is the expression. So
we have 3 more questions. At what age can we fill out and submit an RJI to our county Supreme Court? Does it have to be after our son is 18, or can it be before to jumpstart the process?
Okay, so Nancy and Wendy, I think you answered this person. It's not Supreme Court. We're talking about the Article 17A, unless you're going for an Article 81 in Supreme Court, and that's a different type of guardianship that we weren't talking about this evening. You could reach out to your local bar association in Nassau County and ask to speak to an attorney. They do have an attorney referral service about the Article 81. And you can ask those questions to them.
Okay, the next one is
interstate guardianship. I'm sorry. The courts are trying to be very friendly with other types of guardian, I'm guardianship here in New York. I moved down to Florida. We just had a case, and this is a very interesting case. The guardianship was done many moons ago, and the parents applied for the transfer to Florida. And Florida said, no, doesn't need a guardian. So this is not just a New York State issue. This is a national issue where the courts are really scrutinizing whether or not the child needs a guardianship. And that child, I will say, he drives himself to work. There was some facts that, way back when he wasn't doing that, but now he is. So if you're driving, the courts will say, no, you can't, you don't need a guardian, right? Think about it. I'm behind a wheel, I'm a licensed driver, I'm navigating the roads, then that person doesn't need a guardianship.
Next one. Hi again. My son's father is overseas. We're divorced. I have full custody with his consent with my home's country local court's decision letter. Do I need to prepare anything regarding his father's consent? Is it required?
If you download the forms through the court or on our website, parent or an adult sibling or a half sibling as an adult does have to consent, and they do need to sign before a notary. Now, overseas, it's an apostle. So they have to sign before and obtain an apostle signature. It's almost like a notary. So yes, you do need consent. If you don't have consent, the court will be looking at what efforts have you made to obtain consent, and has to be shown, not just by word of mouth. You have to show how you've submitted documents and so on to this person. And then there will be a hearing, definitely, because the other parent didn't consent. So I had a case where the father left the family. I don't know how old the child was at the time when he left, didn't pay any child support, did not send any birthday cards, did not even make any phone calls. And the mother was friendly with his family. His family didn't even know where he was. So there was a hearing, and the mother had to testify to that effect. Nope, he didn't pay any child support. Nope, he didn't do this. Nope, he didn't do that. And I saw the expression on the judge, and guardianship was going to be granted to that mom. So it is a process before you get, to get there.
Next one is, can you appoint someone the guardian in case something happens to you?
So that's a standby guardian. And we discussed that process. Sometimes people will make their adult sibling or another loved one as a co-guardian, because it is, as a standby, I have to petition the court saying, hey, I'm ready to step in. And there's a lag. And so what some families do is they will appoint that other adult now. You don't need to have both guardians at the doctor's office to make decisions on behalf of somebody. It's one guardian, or that could go to the doctor's office. So we have not encountered that at all. And again, the parent may appoint their adult sibling or somebody that is younger, because they're fearful if something happens to them, who's going to be able to make medical or dental decisions for their child. And the guardian, I just want to say this, a lot of times families approach their loved ones, will you be a guardian? Will you be a standby guardian? I think you have to, you have to convey to them it's only for medical decisions and dental decisions under the 17A. That child does not have to live with that person. I think there was somebody with a trust and a group home. Yes, so the person for the guardian could be living in Colorado. The person who needs the guardianship, otherwise known as the ward, could be in a group home, and that guardian in Colorado could be a fantastic guardian. Actually, it was, she was the niece, and the gentleman had lived in a group home all his life, and she's known him, and she has a very loving relationship, but she now lives in Colorado. She became a guardian. So, and she participates in medical decisions. She was involved in the meetings. You can call in, you could, video conference in. So, yes, if that answers your question.
One more, and I think we're caught up for now. Do you mean a temporary guardianship takes 8 months or a regular guardianship? Also, can the guardianship give the power to decide on where I decide where my son, okay, somebody just moved me, where my son will live against his desire?
Mm. So, all right. So I need a guardianship, right? And my guardian wants to make me live in a facility. And I am kicking and screaming and I don't want to go. That facilities may not want me there because I am saying no. So it's you'd have to have that conversation with the facility. I mean, obviously there are some facilities that are secured for, the person is a danger to self or others. So it's just not because I don't, that person is objecting. I have to show that if I don't live in that facility, I'd be a danger to self or others. And again, temporary guardianship, again, I've never seen a temporary guardianship under 17A. Maybe you're referring to an Article 81, which is a different type of guardianship.
All right, there's one more. If my son who has autism and wants to try to get his license, he currently has his permit, can we still apply for guardianship? What is shared decision?
Supported decision, not shared. Supported decision making is a process where like every day I make a decision, right? I don't make it in a vacuum. I am reaching out to others before I move forward. For medical decisions, I have a friend who's a doctor. I'll reach out to her. Oh my gosh, you know, um, you know, she's so wonderful for me and will be clears up some aspects of making a medical decision for myself. That's supported decision making. We do it every day, but I am making the decision. What was the first part of the
Her son has autism, currently has his permit. She wants to know if he gets his license, will he still be able to apply for guardianship? She still be able to apply for guardianship?
It's the death now. Okay. So during the hearing, if the judge asks, do you want to drive? Yes, I have a permit. Okay, not going to be granted. The guardianship will not be granted. I'm just, and this is just my opinion. That's all. And I want to drive. Yes, I have my permit. I'm going for driver's lessons and I should have my license within 6 months. So if the judge asks that, it's going to be a problem. So maybe that person needs advanced directives, having that conversation with your child about advanced directives and helping them make decisions. Right? I mean, we do it naturally all the time with our children.
Somebody's asking a question about They would just want to be clear, is the Article 81 guardianship also permanent like the Article 17A guardianship?
Yes and no. There is an annual review process. You have to, it's an annual, it's called annual accounting, annual reporting. So there's aspects of it where if I'm the guardian, saying how much of the property, how much am I managing the property? I started with 100,000. I spent this kind of money on this and that, and now I have, 89,000. The other part is the social and other aspects, community aspects of the guardians, I'm sorry, the ward's ability, if he's involved in the community, if he's working and so on. And then that is submitted to the court evaluator. So if I'm writing in an annual report and I say that my son is, working, he's managing his checkbook, and he's able to do a number of things, maybe that guardianship might not be terminated, but it would be watered down because my child is gaining some skills and they don't need a guardian for all aspects of their life.
I think the person who wrote the license question is asking again, so should we do the support decision?
Well, what you need to do is, I don't know how old your child is, but at age 18, the conversation, supported decision-making, you still need a power of attorney and a healthcare proxy and a HIPAA. So supported decision-making, is being recognized by OPWDD, but again, as I mentioned, it's not really being recognized in the banks or at the hospitals or with the doctors. So you still need those documents to be prepared. You could go to the Department of Health, New York State Department of Health, and download a healthcare proxy, and your child will have to, fill it out and sign it before two witnesses. And it shouldn't be you as the witness, you have to have independent people. And, a power of attorney, it should be done, under the supervision of an attorney. That's just my, opinion, because it is a legal document and you're naming it. And when I talk to someone about a power of attorney, let's just say Wendy comes into my office and she wants a power of attorney. And she names her good friend Nancy. And Nancy, I'm going to tell Wendy, is a human being. And if Nancy starts going to Jake's 58 every day, or she's on Home Shopping Network every day and she's ordering 5 lawnmowers and she lives in an apartment where, you love Nancy, but you're going to have to remove Nancy. So, and I have those conversations with people all the time about that. I have loved ones named on my power of attorney. If any one of them is starting to act in some sort of fashion that I don't feel confident in, I still love them, but I'm removing them from the power of attorney because it's so much needed. I need them to be a success for me. So if they can't be a success for themselves, those agents shouldn't be named. So if your child can understand that you're naming mom and dad, but if mom starts going around the bend, you're gonna have to remove her. And I've had conversations with people about that, and it's been successful. And I think we're at the end. So are there any other questions?
Regina, I did find an article for and it's from 2025, this year. The Hofstra Laws 17A Guardianship Project.
Oh, great.
So they can
Great.
go on that, right, and then I'm sure there'll be a contact information on there.
Yes, and I know Nassau Suffolk Law Services now under a different title, Long Island Legal Services, they do some guardianship too. So that's but I think that is a means test. You have to qualify, for pro bono services. Under Hofstra, I don't believe it's a means test. You'd have to, they'll tell you more so than I, but I've seen them in court and it's nice to see.
We have 3 quick things that people putting in. How much on average does a contested guardianship cost?
Um, how much on average? Oh my gosh. How much is contested? So, I will just tell you, we have a flat fee for a guardianship. It is 2,500 and it includes the hearing. It includes the guardian ad litem because we have to work with the guardian ad litem that's appointed, and so on. If it's contested, it's a matter of, we take it case by case. So that's applying for a guardianship. So we just had a contested matter where the sister was a co-guardian with the other person and they wanted to remove the sister. And that person is on, we worked with them and they're on a payment plan. And luckily it's now settling. But I've heard of some crazy scenarios where people are contesting and, when they're having, they're going to court and they're filing motions and so on. Our office would probably refer that out if someone is, for a contested guardianship. It's just, we're a small office and it takes a lot of resources for a contested matter. And we know some really good attorneys that would take your case.
Okay, we have someone asking about, please speak about special needs trusts. And another question that could be fit with that one would be, can you share more on third-party trust costs?
Okay, so a supplemental needs trust is a fantastic way of leaving your legacy for your child who's on benefits. And again, it doesn't matter if your child is, needs a guardianship or not. I have clients that are individuals that are on Medicaid. They're working people with disabilities and they're receiving Medicaid for various reasons and they're able to self-direct their lives. And they're leading very successful lives. And parents want to leave money for their child to benefit, but they can't leave it to them directly. So they create a special needs trust. It's a third party because it's your child's money never goes in there. It's your money that goes in, grandma's money, Aunt Kathy's money, but it's never your child's money. And the trustee should be someone that you feel that would obviously be trustworthy, follow the rules. So being a trustee, I find that in the beginning, a trustee newly appointed, and I love these type of trustees. I want to do a good job. I want to do a good job. Tell me what to do and so on. And in the beginning, we're helping them and then we give them the rules of the road and they are successful trustees year after year. So you want a trustee that would follow the rules and reach out to benefits counselors, attorneys, and accountants. So that's the ideal situation. And you could have co-trustees. So that's something I think is beneficial, to think about. And then there's a role called the trust protector, where somebody is not necessarily the trustee, but while you're gone, that person could remove the trustee if they're not doing a good job. So you'd want that. So our trust includes the trust, the bank instructions, a trustee letter, and, you know, the funding instructions, and also a letter to Medicaid and Social Security, and that fee is $2,800.
Can you refer me to an attorney that can help me with a contested guardianship?
Well, I usually like to ask questions before I refer to the other attorney. Our office does offer a courtesy consult call. You could call our office, we'll do an intake, they'll schedule a call with either me, and there's another attorney, her name is Wendy too, Wendy Hoder, and she's been doing guardianships for a number of years. So it's all based upon jurisdiction, what the issue is. So I just want to, you know, recommend an appropriate attorney for you, but, you know, right off the bat, you could call up Andrew Cohen out of Nassau County. You could call up Nancy Hampton out of New York City. But, you know, again, I usually like to ask some questions.
And your information is on the screen right now, so that could be copied. And Wendy and I both put it in the notes as well.
Okay.
And you are getting several thank yous and very informatives. And I think we are done with questions.
Okay. I know guardianship is a tough thing, and unfortunately, it's becoming tougher with the courts. I think I conveyed that. Wendy and Nancy, did I do that?
Yes, very well. Yes.
All right.
Yes, I put Andrew Cohen's information up there as well.
Okay, great. And Nancy Hampton's out of New York City. I don't know her. I could probably look up her number real quick. And, you know, a lot of people, Andrew Cohen does guardianships too. He's my colleague and also, you could say, competitor, but we're, you know, it's a collegial type of, so let me find Nancy Hampton. Okay, so the number I have is 212-239-2000. That is her office. And she has an interesting background. She worked for law firms that represented the group homes and so on. So I think she has a nice background relating to a number of issues about the guardianship. Okay.
Okay, well, thanks so much, Regina, for taking the time to share your knowledge. These are really important topics. And thank you, everyone, for participating this evening. Have a good night.
All right.
Thank you, Regina. Good to see you.
And likewise, and spring is almost here.
Oh. Have a good night, everyone.
Okay,
Thanks.
bye-bye.
Bye.